Hi there. Welcome, Employment Law Show. We are back for another week. So good to have you along. John Scholes, your host, and with me, of course, employment lawyer Lior Samfiru. Reach out anytime to Lior. Sometimes if it's a chat you want to have on the phone or email, there's both options, right? 1-855-821-5900. Help at employmentlawyer.ca. Other than that, a lot of stuff that we talk about here on the show, you can educate yourself on your own time. On your own cell phone or your tablet, go to pocketemploymentlawyer.ca. While you're there, you'll have access to the severance calculator, which Lior will talk about here in just a bit, and we'll run a schematic, a scheme through it, and see what comes out the bottom end. It takes about 30 seconds to use the entire website, the whole app, so it's really simple. Again, pocketemploymentlawyer.ca. As you know, every week we have a main topic. This week, temporary layoffs, true or false. I get to question the big guy, so that's coming up in just a bit. We'll get to some email questions, possibly some phone calls from one of our radio shows across the country. So we got a lot of stuff to get through. So let's get it happening, Lior. I always start off with the case of the day or the week that was, pal. What do you got going on?
John, great to be here, of course, to talk about employment law. I talk about employment law on this show. I talk about employment law in the office. I talk about employment law a lot because it's such an important topic. If you have a job, if you're working, you need to know your rights. You have rights. But think about it. Aren't rights kind of useless if you don't know what they are? Well, that's why we're doing this show, to tell you what your rights are if you lost your job, to tell you what your rights are if you're being mistreated by your employer, if you've been given an ultimatum, if your job has changed, if you're put on a temporary layoff. All those things and much more we cover on this show so that we arm you. We give you that power of knowledge, and we make sure you don't get taken advantage of. You don't walk away from rights. On this show, we talk about those rights you didn't even know you had. But of course, this is a 30-minute show. As John said, I'm not going anywhere when the show is off. I'm still available to talk, email, phone, and also, of course, to roll up my sleeves and to help you actually enforce those rights. So don't hesitate to reach out. Let's have that conversation. But let's start with a case that came across my desk just over the past few days. I spoke with a gentleman that had started working for his company almost 10 years ago. Now, for the first 6 years, he was considered by the company an independent contractor. He was invoicing the company. He was still working full-time, but he was invoicing the company. They pay the invoice. Well, 4 years ago, company said, we want to change you to an employee. So they did. Nothing really changed for him. His job stayed the same. They just put him on payroll. Well, fast forward to now. Unfortunately, the company is going through a restructuring, and they had to let him go. So it's time now to decide what severance he's owed. Company says, well, you've been an employee for 4 years, so we're going to pay you severance for 4 years of employment. He then calls me. Thankfully, I'm so glad that he did, because he watches this show, and he wants to know whether that is okay. Does he only get severance for the 4 years, or really is there credit for the 10 years he'd actually been with the company? So this actually is a situation that happens often. You don't just magically start being an employee if you've been working for a company. He was an employee all along. All that means is for the first 6 years that he was there, he was misclassified. They called him a contractor, but he was an employee. It doesn't matter what the company calls you. Frankly, it doesn't even matter what you may believe that you are. If you look like an employee and act like an employee, yeah, you got it. You are an employee. So he was really an employee for 10 years. Doesn't matter what the company did 4 years ago. So the severance that he's owed now is for 10 years. I assessed him as being owed about 12 months of severance. The company was offering less than half of that, so I'm going to help him get that severance. But remember, there's a good chance, if you think you were a contractor, whether now or in the past, that you really are an employee. And that's important, especially when it comes to your severance. Severance should account for all years, so don't walk away from your rights. If you lost your job, if you think you've been misclassified, you have to call me right away.
So any of the viewers, Lior, that are wondering, okay, well, how do you know? How did you determine he was an independent contractor? And how did he know to make that phone call to you to have that discussion? Like, what are the criteria that would make him a contractor over that 10 years and not an employee, right?
Well, John, if you work for a company, you are likely an employee of that company. A contractor is someone that's in business for him or herself. They have many clients, many customers. They provide services to various people. If you work for one company, if you do what they tell you, if you're out there representing them, you are an employee. And by the way, John mentioned at the beginning of the show the Pocket Employment Lawyer. You can find that, of course, at pocketemploymentlawyer.ca. We have a tool there, free and anonymous, of course, that allows you to determine if you're actually a contractor or if you've been misclassified and you really are an employee. So check it out, and if you're not sure, do the right thing like this guy did, call me.
If there's a place to fit for somebody who, say, I mean, just for an example, they work at one place and they maybe do 60-70% of their business, but then they go to 3 other clients and they do some work with them as well, is there a category for them?
So that's the in-between. Between an independent contractor and an employee, we call that a dependent contractor. A dependent contractor is someone that's not an employee but gets most of their work, most of their income from one place. That dependent contractor is treated like an employee for severance purposes. So you may actually not be an employee and still get your full severance if you're in that dependent position. So yeah, even more of a reason to call me anytime you lose your job. Doesn't matter what you are, how you bill yourself, what companies you work for, chances are there's still compensation owed to you.
Lior and I, other lawyers in the firm, been doing a ton of radio across the country for years with regard to this particular topic, the employment law show. Go to employmentlawyer.ca to find a station near you in your neighborhood or close by that you can tune in, or online for that matter. Get some phone calls from those shows, Lior. We play them back. Let's take phone call number 1 coming up right now. Listen up.
I have 4 years with this company, a senior executive. Employment contract states that without cause termination, I'd be entitled to receive 1 month for every year of service. Anticipate termination is going to be coming up shortly. And I'm just wondering that even if the employment contract was signed, would we be entitled to more than 4 months?
What do you think?
So it's very common to have individuals that sign employment agreements that try to speak to the issue of termination, that try to limit entitlements. Well, just because you signed an agreement like that does not necessarily mean that it is enforceable. In probably 80%, 75, 80% of these cases, when your employment agreement tries to limit your entitlements, it doesn't do so properly, and that means you are still owed your full severance. And that could be a massive difference between what the company says you should be getting and what you're actually owed. Well, in this case, if this person, that agreement does not properly limit their entitlements, the question is, are they owed more than 4 months of severance? Well, let's go and use our severance calculator for the first time today. Let's go to pocketemploymentlawyer.ca. Let's plug in the information and see what we have. So we know that this person is in a senior executive role. They're in their mid-40s. They were there for 4 years, and they were offered 4 months of severance. Wrong. You see right there on the screen, this person is owed 8 to 9 months severance, so double what they've been offered. That's why you use the severance calculator. That's why you go to pocketemploymentlawyer.ca or call me, because chances are, even in the face of an employment agreement that you've signed, that you're owed much more than what the company's paying.
Is that because the agreements could be outdated? I mean, do you have to update them that regularly? Every 3, 4 months, 6 months? How often should an employer do that?
Well, it's not easy to draft an employment agreement that limits severance. It's not easy. The rules kind of keep changing. So unless it's something that was drafted by someone very knowledgeable very recently, chances are it's not going to meet all the criteria to limit entitlements. And that's why we got to talk, because there's usually several ways we can get out of that agreement that tries to limit your severance.
So no Google template here.
Oh my gosh. Well, I mean, for an employee, if their employer uses Google templates, that's a good thing. For the employer, terrible idea. Whether you're an employee or an employer, you got to get proper advice if you want to abide by the law.
That was phone call number 1. Phone call number 2 is coming up right now. Let's listen up.
Employed with a company for 6 years. A competitor headhunted me, for whom I worked 9 months. I was exposed to a very toxic work environment. When I brought some of my concerns up to senior management, and the next thing I knew is I was terminated. I was given 2 weeks severance. Feel like because I was headhunted at 6 years prior, I was working in a company should be taken into consideration.
All kinds of wrong going on here.
Yeah, there's a few things that we need to unpack. Well, first of all, you cannot be fired because you express concerns about workplace harassment or a toxic work environment. It's illegal to let you go in that situation, even with severance. You're protected. The company has to take that seriously. They have to investigate. They have to fix the problem, not punish the person that's raising it as an issue. Now, beyond that, he's absolutely right. Because he was recruited away from another company, he's been there for 6 years with that previous company, that 6 years will count towards his severance. That's what happens. We call this inducement, where you're recruited from a company only to then be let go by the new company a short time later. You're going to be owed enhanced severance. So this person may have only worked for 9 months, but that 6 months he had with the previous company counts. So now he's a 6-year plus a 9-month employee. He could be owed 8, 9, 10 months of severance, even though he only worked for a few months. So important lessons there for employees and employer about what the law says in those situations.
All right, we'll take a short break. Phone call number 3 is on the other side, and we'll get to our main topic, temporary layoffs. True or false? To get the question the big guy, that's on the way. In the meantime, always reach out to Lior and his team, 1-855-821-5900, help@employmentlawyer.ca. Lots more of the Employment Law Show is on the way. Stay with us. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Employment Law Show set to go with our main topic after our third phone call. You can always reach out to Lior and I on the phone call. Some of the shows are an hour long, some of them are a half hour across the country, but go to employmentlawyer.ca. Find a radio station near you, and you can do the same. So let's get to phone call number 3 and see what it's all about.
I have an elderly parent. She's 85 years old, and she has a vision disorder and both legally blind in one eye. And she recently had a fall. And I'm wondering if I could ask my employer if I'm eligible to apply for a family status accommodation.
And what kind of accommodation would you need?
I would like to work remotely so that I can look after my elderly mother. And I've been doing that for the past 2 years, but I was recently called back into work.
This seems like kind of a no-brainer, right?
It is a no-brainer, and it's something that an employer must do. This is actually a very common situation. Many of us have older parents, and we have these responsibilities to them to care for them. Well, guess what? Under human rights laws, an employer must accommodate based on family status, and that includes being in a parent and child relationship. So in this case, that means that employer needs to provide this accommodation by allowing this person to work remotely, if that's really the only accommodation that makes sense, so that he can care for his mother. Now, here's what I would do. I would write to my employer in this situation and tell him, here's the accommodation that I need, here's why, and by the way, here's why there's really no other viable option for my mother to receive care. I don't have brothers and sisters that can do it, or any other people that can do it. It's on me. At that point, the employer must accommodate. We know that they can. This person used to work remotely, so it's not a stretch at all. And that duty to accommodate under human rights laws is a very, very important one. The company doesn't get to say no. It's not up to them. You don't need their approval. They must do it. If they refuse, that could be a human rights violation. That's illegal. So send that note, and what I would say to this person, if they don't provide that accommodation, call me. Once they hear from me, yeah, they'll probably accommodate.
Is there a time limit on how long he can extend that for, or as long as needed? Right?
As long as needed, yeah. As long as the employer is able to offer that accommodation, they must provide it. Now, at some point, maybe the job changes and something happens that there's just no possibility to accommodate. That's going to be very unlikely. If that accommodation is possible, it must be provided.
During that time, is the employee responsible to try to find alternatives to get it back to normal if they can?
Correct,
Try
yes.
to mitigate a little bit, right?
So you're kind of the first line of defense in terms of the accommodation that you need. If you can accommodate yourself or find a solution without engaging your employer, you have an obligation to do that. The employer is there to kind of be that stopgap measure. If there really isn't another way for you to provide that care, unless your employer accommodates you, then they have to accommodate you. It's not a situation, well, it's just be easier for me if you accommodate me, employer, so do it. No. So yes, you have to see if there's other measures that you can find, but if there isn't, you just need that accommodation from your employer. Your employer must accommodate. And by the way, we talked about a parent. Certainly same thing applies to your child.
Yep.
Maybe you need to provide care for your child. Maybe you need to be there at a certain time to pick them up or drop them off because there's no other ability or no one else can do it. Even in those situations, your employer must accommodate.
All right, let's get into our main topic for the show today, Lior. Temporary layoffs, true or false? I ask the questions, he answers them. Number one, employers can lay off employees temporarily without their consent. True or false?
That is false. And a lot of people are surprised by that. A lot of people think that my employer has the right to decide that I go on a temporary layoff. No, not the case. Remember, we talked many times on this show about constructive dismissal. And if I were to say my employer wants to reduce my pay by 50%, you would say, of course they can't do that. That's insane to reduce it by 50%. Well, what is a temporary layoff? How much of a reduction is that?
It's 100%.
It's a 100% reduction. Yeah. So certainly, if your employer can't reduce your pay by 50%, of course they can't, they cannot reduce it by 100%, which is a temporary layoff. Therefore, if your employer is doing that, in most cases, that's not legal. You may be able to treat that again as a constructive dismissal. That doesn't mean you can physically force your employer not to do it. But you can treat that as a constructive dismissal and force your employer to pay you your severance. So no, it's not an automatic right. In some situations, if your employer had you sign an agreement that gives them the right to do that, they may be able to do it. But for most people, no, you cannot be put on a temporary layoff without you agreeing to be on one.
Okay, question number two. Temporary layoffs are also allowed if they are common practice in the entire industry.
Yeah. Well, in some situations, it's kind of obvious, right, that the industry can't, if you're plowing snow, well, you're not going to be able to plow snow in the summer.
Or pool cleaner.
Or a pool cleaner, right. So if the type of job that you're doing is obvious, that it cannot be done in a certain season, then a temporary layoff is implied. But no, it's not automatic. Just because others in the industry are doing it doesn't mean that in your workplace that's the case as well. There's many jobs, let's say, that are in construction that can work year-round. Maybe some people don't, but the fact that other companies don't doesn't mean that your company is allowed to put you on a temporary layoff. Yes, even those in constructions cannot necessarily be put on a temporary layoff.
Temporary layoff, true or false? Question number three is coming at you right now, Lior. Accepting a temporary layoff can set a precedent for future layoffs. True or false?
That is 100% true. That is correct. And that's a huge problem. Think about it. I just said that your employer doesn't have a right to put you on a temporary layoff. But what happens if you accept it? You don't want to rock the boat. You want the job. You'll just sit at home and let the company do that and come back when they call you. Well, the problem with that is that by doing that, you've set that precedent. You've given the company the right to do it again. And the next time they do it, and the time after that, and the time after that, you're not going to be able to do anything about it because you let it happen that first time. So you may now create a situation where you work for a few months, you're on a layoff temporarily for a few months, back and forth, and that's not a good thing to have happen. So you may want to not do that. You may want to say, no, I'm not okay with it. And if the company's going to proceed anyway, you may be better off getting your severance and moving on to another place.
Okay, true or false? Number four, your years of service stop accumulating while you're on temporary layoff. True or false?
That is false. Right. Your years of service continue to accumulate. Now, maybe you've decided, I'm not going to treat this as a constructive dismissal. I'm going to accept this temporary layoff. That's your right to do that. So those weeks, months, etc., that you're on a temporary layoff count towards your seniority. So later on, your employment is continuous and it doesn't start on the date that you came back from that layoff.
We'll get to one more here, Lior. True or false? You can treat a temporary layoff as a termination and get full severance pay. Top tip.
For most people, that is true. Absolutely. For most people, if you're on a temporary layoff, that choice that you have is between accepting it, which I said is very problematic, or considering that a termination, a constructive dismissal, and getting your full severance. That severance, of course, as we know, John, could be as much as 24 months' pay.
Lots more to go. More of your questions on the other side of the short break, which we'll take right now. You want to reach out to Lior in the meantime. Always have the number with you, 1-855-821-5900. Email, back it up with that, help@employmentlawyer.ca. Lots more to go. Stay with us. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back, Employment Law Show. Lots more to go. Thank you for tuning in this week. You can always reach out to Lior and the team. Phone number first, sure, 1-855-821-5900. Email is help@employmentlawyer.ca. And for all other concerns, we've talked about the website so far. It was standalone, and with it is the severance calculator. That website is pocketemploymentlawyer.ca. Keep it, pocketemploymentlawyer.ca. Covers a lot of what we talk about on the show, and as I just mentioned, that severance calculator, free and anonymous to use. It'll give you a good guide, a quick guide on how much severance you are owed if it comes down to the time where you're definitely looking for that number for sure, pocketemploymentlawyer.ca. But want to go to this website, terminationquestions.com. You can ask your questions there anonymously. They will get answered, maybe appear on this show, maybe today, maybe tomorrow, maybe the next show. If not, they will get answered. Lior, for this week, here we go. Says, I have worked as a manager at a company for almost 20 years. They were going to be bought recently, but the deal fell through. I sense ownership may just shut it down. I believe I'm entitled to roughly 8 weeks' pay, but I'm wondering if I should be receiving more. I'm 62. What do you think?
So, John, just because a company is shutting down, they decide to stop operating, does not mean you don't get your full severance. The only time a company may not be able to pay it or may not have to pay it is in a formal bankruptcy situation, not because they shut down. So the company shutting down does not change the amount of severance that you are owed. Now, this person is assessing themselves as being owed 8 weeks of severance. Oh my gosh, absolutely not. Much, much more than that. Remember, your severance is not a week per year of service. It doesn't get capped at 8 weeks. It's not 2 weeks per year of service. The factors are your age, your position, and the length of your employment. So we want to know how much severance this person is actually owed, and it's not 8 weeks. So we're going to go once again to the severance calculator. You can find that at pocketemploymentlawyer.ca. Let's plug in the information right now and let's see what we get. So we know this person is in their 60s in a managerial role, been there for 19 years, almost 20 years. Believes this person that they're only owed 8 weeks severance. Well, no. You see right at the bottom, they're owed 20 to 24 months severance, as much as 2 years of severance. That's a massive difference between that and 8 weeks. That's why you go to the severance calculator. That's why you use it. It's free and anonymous. So check it out at pocketemploymentlawyer.ca.
I'm just wondering where that 8 weeks came in. Like, even for someone who doesn't know, 8 weeks seems like a really low number. I don't know where they got that from.
Well, that's misconception 252. Where an employee believes that severance is capped at 8 weeks. Common to hear that and see that, but again, misconception. It's wrong. It's false. Severance gets capped at 2 years, and even that is not a hard and fast rule. For some people, they can get even more than that.
Yeah, because this person seems to have hit the triple crown of being maxed out near their manager. 20 years service and over 60. Those are 3 big numbers, right?
Yeah, they score highly on all of those main criteria, which is why they will be getting right around that maximum, that 2 years of severance. So it doesn't get capped at 8 weeks. And by the way, another misconception that may be related to this, size of the company. Remember, the size of the company or the size of the company's payroll, not relevant. Your full entitlements have nothing to do with that, are not going to be impacted. Whether you work for a company with 1 employee or 1,000 employees, your full severance is going to be the same.
You can reach out to Lior and his team as well on the live stream, YouTube, Facebook, LinkedIn. The address is at stlawyers.ca, at stlawyers.ca. Here we go, Lior. I made a mistake at work, and instead of firing me, my director issued a warning. I have since found out that the company is restructuring and removing several roles in my department. Can they use my past mistake to fire me for cause now?
Well, remember, it is very difficult to terminate for cause. And just because you did something wrong does not mean you can be let go for cause. So what would the company have to do here? Number one, they would have to show that the person did something else that was wrong. The fact that they did something a year, 2 years, 3 years ago doesn't matter. They would have to show whether they did something again. There's really no opportunity to be able to fix this relationship. That's going to be pretty tough to do. So no, realistically, this person cannot be let go for cause. Just because you were warned, just because you may have made a mistake, does not mean that the company can automatically jump to the capital punishment of the employment relationship, which is a termination for cause. No, it's really a cause is an all or nothing type of a proposition. There's no such thing as kind of almost cause, doesn't exist. Either they have cause 100% or they don't have it at all. And in my experience, been doing this a long time, most of the situations where the company says, we have cause, we don't have to pay you severance, they don't. It's not even close. And yes, you are owed your full severance. Unless you stole, unless you hit somebody, unless you sexually harass someone, chances are that whatever you did is not bad enough to rise to the level of cause. So if the company tries to go that route, you call me and I'll make sure you get what you're owed.
So this company would have to build up more of a case, maybe put them on a performance improvement plan before he even gets to the point of firing them, right?
If they want them gone, they can let them go at any time as long as severance is paid. But if they want to allege cause, then they have to build up that case. They have to make it clear that there's just no other opportunity in fixing this relationship. We've tried, we warned them, we helped them, they're not getting it. Unless the company is prepared to put in that type of work, they cannot successfully allege cause.
And we'll get to this part now. Lior loves this part. We speed it up a little bit. It's called Rapid Fire Employment Rights. The Rapid Fire is coming up right now. All right, Lior, here we go. You're in the hot seat again this week, pal. Number one rapid fire question. Is severance pay mandatory upon termination? Good question.
Generally, yes, it is mandatory. If you lost your job, you are owed severance unless you did something terrible, unless the company can let you go for cause. So if you want to know if severance is owed, ask yourself, did I have a job? Okay, I did. Did I lose the job? Yes, I did. Then guess what? You are owed severance. Full-time, part-time, young or old, the same thing applies.
Rapid fire number two. Do you get advance notice of termination?
Well, the company either has to provide you advance notice or pay you severance, or they can do a combination of the two. So if you're owed 10 months severance, the company can give you 10 months notice, or they can give you 10 months severance, or any combination of notice and severance. That's that 10 months in that example. So one of the two must be provided notice or severance.
Rapid fire number three. This one's for the employers out there. Does an employer have to accommodate an employee if it involves additional money, additional cost?
Yes, absolutely. Accommodation, the duty to accommodate, whether you have a medical condition or you need other support, that accommodation must happen even if it costs the company money. It's assumed that accommodation may be difficult and may even cost the company money, and that's no excuse to say we don't want to do that. Now, of course, if the accommodation is so difficult or so expensive, well, the company may not have to go to an extreme. But for most people, even if the accommodation costs money, it must be provided.
Number four, this is nice. Can your employer fire you while you're on vacation?
Not nice, kind of a crappy thing to do. But yes, legally your employer can let you go while on vacation as long as severance is paid. The vacation does not change the analysis, so severance becomes the issue here.
And number five, is your employer obligated to provide you with a written contract?
No, an employer is not required to provide you with a written contract if you signed, if you're starting a job or if you're working or if you're promoted. In fact, you don't want that contract. That written contract, if you're an employee, is not your friend. You'd rather have a handshake deal, an email deal. Nothing in the contract is really of value to you. It potentially takes away your entitlements. So if you have a deal with the company, as long as we know what the deal was, that's all you need. Don't insist on that written contract.
All right, finally and quickly, is there a time limit on when you can try and get severance?
Well, you can pursue severance up to 2 years from when you lost your job. That's a strict 2 years. It's not kind of 2 years. So that's why you can take the time that you need and wait up to 2 years.
And we just got it all in just in time. I'll leave you some contact information as we wrap it up here to reach Lior. Phone number 1-855-821-5900, pocketemploymentlawyer.ca, and help@employmentlawyer.ca as well. We'll catch you next time in the Employment Law Show. Thanks for tuning in.